Hello everyone. I understand this is the last module for the training on achieving redress for victims of torture with mental disabilities in Africa. It's a pleasure to speak to you about remedies and reparation for victims of torture under international law, which is the focus of this module. I must apologize at the outset for a relatively noisy office, but I can only hope that you understand me loud and clear. My name is Jürgen Schur. I'm Head of Law and Policy at Redress, a human rights organization based in London, the United Kingdom, and in The Hague in the Netherlands. We were founded by a torture survivor in 1992 who himself, after he had been tortured, sought to access justice for the torture committed against him in Saudi Arabia, and then founded Redress to assist victims who, just like him, were seeking redress. We work worldwide supporting victims of torture and related international crimes in accessing justice and obtaining reparation. Much of our work, especially over the past years, has focused on advocacy, capacity building, and also litigation in regards to torture committed in Africa, often using and working with the African Commission on Human and People's Rights. At the outset, I must say that we have not yet been involved to a great extent in working on torture specifically in the context of mental disability, but I hope that some of the lessons learned in our general work will be helpful also for your work, and we come back to that later. So that's about our organization. You can find out more about us, about Redress, on www.redress.org. As I had mentioned, today I'll speak to you about the right to redress for victims of torture under international law. As you may know, the right to redress and the corresponding obligation of states to ensure that victims of human rights violations, including torture, obtain redress has developed significantly over the recent years. And today it's a well-established and basic human rights enshrined in universal and regional human rights treaties and instruments. However, similar to the absolute prohibition of torture, which is also universally recognized in the peremptory norm, there's a substantial discrepancy between the obligation to provide redress and its application in practice. In our work, and I'm pretty sure that you come across that too in your work, we see that the vast majority of states fail to provide victims of torture with full redress in law as well as in practice. Challenges for victims seeking redress are many and include lack of adequate legislation, absence of effective policies, programs, administrative measures, and independent institutions to give effect to this right to redress. Impunity and gaps in the rule of law, as well as socio-economic challenges, frequently prevent victims from obtaining redress. These obstacles are exacerbated in regards to marginalized groups, who not only because of their marginalization or because they are disadvantaged are prone to a higher risk of torture and ill treatment, but they are then also less likely to access and obtain full redress. In turn, this makes our work much more important. It makes a good understanding of what the right to redress is and what it entails in terms of obligations for states so important. Where states fail to provide redress, regional and international human rights mechanisms can help to strengthen the right to redress at national level. So that brings me to today's topic. We'll first examine what redress is and what it means before looking at the key international and regional legal frameworks and standards pertaining to the right to redress. We'll then examine some of the key jurisprudence regional as well as international, but with a focus on the African Commission as far as redress for torture is concerned, and in particular consider the different types of reparation awarded by human rights mechanisms such as the African Commission for Torture. The last part will assess to what extent the existing legal framework, standards and jurisprudence can be used to strategically litigate for specific remedies in the context of torture, including torture of people with mental disabilities. Again, with a focus on the African Commission and the African Court. As I think you've heard in previous sessions, there's not much specific litigation on this issue yet in the African context, or indeed, I think, anywhere. So hopefully the lessons learned in other cases can be usefully applied in support of cases involving people with mental disabilities. I understand that you've been provided with a pre-reading list. If I may add to this 2 reports written by Redress that could be useful for today's topic and generally for litigation on torture. One is this report called Reaching for Justice, the Right to Reparation in the African Human Rights System. It examines the issues we talk about today in much more detail, and in particular looks at the African Commission's jurisprudence on the matter. And a manual which we published in November 2016 on litigating torture and ill treatment in East Africa, a manual for practitioners. This does not specifically publish this together with the Independent Medical Legal Unit in Kenya. The manual does not focus on the right to redress, but looks at litigating torture more broadly, though it might be helpful also for your work in the region. This would then bring me to the next point. What is the right to redress under international law? So this section looks at the right to redress under international law. We will look at what is redress and the concept of redress, including the right to an effective remedy and the right to reparation, before looking at the international and regional framework and standards grounding the right to redress for victims of torture. So let's start off with what is redress. The right to redress has 2 key components. Firstly, the right to an effective remedy, and second, the right to adequate and effective reparation. So together, an effective remedy and reparation form the right to redress. Both are crucial components and are indivisible of the right to redress. States need to put in place a process or a procedure, i.e. the remedy, through which victims can obtain reparation. So let's break that down into the different components. The right to an effective remedy, as I said, is a crucial component of the right to redress, and indeed a crucial component of any right. It provides victims of a human rights violation or of a rights violation with a procedure by which they assert their rights and seek reparation for the violation committed. As such, all human rights treaties and instruments require that state parties provide remedies under national law. And we'll come back to that in the next minute or so. Where those remedies at the national level prove to be ineffective, regional and international mechanisms come into play. The African Commission on Human and People's Rights, the African Commission, usually considers the question of whether a remedy is indeed effective in the context of its admissibility examination. So when it considers whether a complaint is admissible under the African Charter and its rules of procedure, as well as when looking at whether a state party to the African Charter has met its procedural obligations under Article 5 of the African Charter in relation to allegations of torture. So we have extensive jurisprudence from the Commission and other human rights mechanisms as to what constitutes an effective remedy for torture. According to the Commission's standard formula, the remedy needs to be available without impediment. It needs to be effective in the sense that it guarantees a prospect of success to the victim. and sufficient so as to be capable of redressing the damage done. Now, what does the Commission mean by that? For instance, in relation to availability, in cases we are litigating in support of victims of torture in Sudan before the Commission, we often submit that remedies in Sudan are not available to victims, as the domestic legal framework provides for extensive immunity of state officials for crimes, including torture, committed by them. And so the domestic legal framework prevents victims from accessing remedies and renders remedies unavailable and therefore ineffective. Where complaints submitted to domestic authorities are not being investigated, or where they are continuously delayed, closed, opened, then closed again, then open again, and there is no progress, we can argue that there is no prospect of success of the remedy, thereby rendering the remedy ineffective. This also applies to scenarios where we have widespread or massive human rights violations, where we would argue, for example, and where the Commission has already rendered decisions and where there is jurisprudence of the African Commission, it is impractical to exhaust domestic remedies because given the magnitude of the violations, for example, in the context of conflict, there is no prospect of success for all of the complaints to move forward. It is also standard jurisprudence of the Commission and also other human rights mechanisms that allegations of torture require states to carry out a criminal investigation, irrespective of whether or not there is a complaint. So, where states are or should be aware about alleged torture, they will need to carry out a prompt, impartial, and thorough investigation that is capable of leading to the identification of and, if appropriate, prosecution of those responsible. Where a state does not investigate and submits, for instance, in response to a complaint filed before the Commission, that a victim should have submitted a civil claim for damages or addressed the case to the Constitutional Court, the Commission does not usually consider this as a sufficient remedy, as for allegations of torture, a criminal investigation is required. Furthermore, and we'll come back to that in a minute, for a remedy to be sufficient, it must also afford the victim with adequate reparation. Overall, as far as the effectiveness of a remedy is concerned, for severe human rights violations such as torture, it is common jurisprudence of the Commission and other human rights mechanisms that the remedy provided must be judicial in nature. A purely administrative remedy would be insufficient, and the Commission has also considered, for instance, that victims do not need to turn to an ombudsman or to the National Human Rights Commission in order to exhaust domestic remedies, as those avenues are not judicial and therefore not effective to address allegations of torture. There are also other procedural requirements concerning the effectiveness of a remedy that we as litigators need to take into consideration. It's important, for instance, to assess the quality of victims' access to and their experiences of the justice processes. And there are obligations that states need to comply with. The Commission, for instance, has considered in a case that we brought to the Commission involving a victim of rape allegedly committed by security forces that the authorities' failure to respond to the victim's complaint and to keep her informed about the progress of an investigation and the outcome of the investigation rendered the remedy ineffective. I'll now turn to the right to reparation, the second component of the right to redress, and as already mentioned, a remedy is considered only effective if it results in adequate measures of reparation granted to the victim. So what are adequate measures of reparation? What is adequate depends on the circumstances of the case and also the harm suffered. As there are many consequences of severe human rights violations on the victim, reparation must take several forms to address the multitude of harm suffered. As such, it's important to emphasize and to counter potential misconceptions that reparation is only about compensation. Indeed, reparation must go beyond simply providing compensation. And it's established that reparation includes a variety of forms, including, but not necessarily limited to, restitution, compensation, rehabilitation, satisfaction, including a right to the truth, and guarantees of non-repetition. I'll explain these different forms of reparation in more detail in the next section after having looked at the international and regional framework on the right to redress. What is the legal status of the right to redress under international law? The obligation to afford redress arises as a consequence of the breach of a primary obligation causing injury. And the origins of the right to redress go back to a ruling of the Permanent Court of Justice, today the International Court of Justice, which held in 1928 in the landmark Jorsov factory case that it is a principle of international law that the breach of an engagement involves an obligation to make reparation in adequate form. Reparation, therefore, is the indispensable complement of a failure to apply a convention, and there is no necessity for this to be stated in the convention itself. The reason why I mention this case is that it's basically the foundation and the origins of the right to reparation. Consistent with the understanding of international law at the time the court made its ruling, a set of rules applicable to states in relation to each other, the law on redress first developed through interstate claims. So under the framework existing at the time, the state of nationality of the victim may seek reparation from the offending state for the violation of its citizens' right. Reparation would then be provided through the state of nationality to the injured victim, who did not possess individual rights separate from the state of nationality. So there was no individual right to redress. Since then, victims' right to redress has developed considerably, especially with the recognition of individuals as rights holders and as subjects of international law. This is also reflected, for instance, in the Universal Declaration of Human Rights adopted in 1948 after the Second World War. The right to a remedy and reparation has been an integral component or part of the development of human rights protection, and as mentioned already, is today an established right in all major human rights treaties and declarative instruments. I'll provide a PowerPoint slide to set out the different treaties, but that do provide for the right to a remedy and reparation. The main ones include, for our purposes, the International Covenant on Civil and Political Rights in Article 2.3, the Convention on the Rights of Persons with Disability in Article 13 with the access to justice, which you are more familiar with than I am, the Convention on the Rights of the Child in Article 39, and the International Convention for the Protection of All Persons from Enforced Disappearance in Article 24, and most important in our specific context when talking about torture, the Convention Against Torture in Article 14. It's also provided for in the Statute of the International Criminal Court, in the Rome Statute in Article 75. At the international level, a range of declarative instruments provide further context and content to the right to redress. These instruments are very important for us also as litigants, as you know, and should not be dismissed lightly as just soft law, as they set out what the obligation to provide redress means in practice, and particularly in regards to torture and other serious human rights violations. These declarative instruments include the UN Basic Principles and Guidelines on the Right to a Remedy and Reparation, adopted in 2005, and which emphasize in particular the state's obligations to ensure that victims have accessible and effective remedies. We've dealt with this in the previous section. Investigate allegations of violations and to seize ongoing violations, to prosecute those responsible, to provide adequate reparation to victims, including all different types of reparation, including restitution, compensation, rehabilitation, satisfaction, and guarantees of non-repetition. And then the UN Basic Principles go on to provide a bit more content as to what we understand under those different forms of reparation. Another more recent instrument, and particularly important for those supporting victims of torture, is the UN Committee Against Torture's General Comment Number 3 on Article 14 of the Convention, which was adopted in December 2012. The committee's General Comment Number 3 sets out in great detail the procedural and the substantive obligations of states arising under Article 14, and so provide guidance to states on how best to implement their obligations under Article 14. It sets fairly high standards and therefore is a great instrument to use for civil society monitoring state party compliance with the obligation to provide victims with adequate redress, but also for litigants to refer to when setting out what states are expected to do in relation to a given case. So, in summary, under international law, the key state obligations in relation to the right to redress include ensuring that victims have accessible, effective remedies through appropriate judicial and also other mechanisms. Maybe one word on that. It's important to recognize that victims of torture and other serious human rights violations do not need to go through a judicial process in order to obtain reparation. So, where victims, or where there are reasonable grounds to believe that a victim has been subjected to torture or other ill treatment, victims are entitled to reparation as well, in particular to rehabilitation. It's not a requirement to go through a judicial procedure. And states must ensure that reparations such as rehabilitation is available to victims, even outside such procedures. States must also ensure, and we've mentioned this, to investigate allegations promptly, thoroughly, and impartially, to prosecute those responsible, and to provide reparation to victims. It's important to stress that a state cannot invoke limited state resources so as to withdraw from its obligation to provide comprehensive redress to victims. The African Commission has furthermore held in several cases that states' obligation to provide redress is inherited by successor governments, and according to the Commission, principles of international law stipulate that a new government inherits the previous government's obligations, including the responsibility for the previous government's mismanagement. The change of government in Malawi does not extinguish the present claim before the Commission. Although the present government of Malawi did not commit the human rights abuses complained of, it is responsible for the reparation of these abuses. This now brings us to the right to redress within the African human rights system. Interestingly enough, and contrary to other regional human rights treaties and conventions, such, for example, as the European and American Convention on Human Rights, the African Charter does not include a separate article on the right to redress. However, as we've also seen in the example just mentioned, that has not prevented the Commission from confirming the right to redress in its jurisprudence, and through the adoption of a range of instruments specifically providing for a right to redress, thereby to some extent filling a gap in the Charter. Even in the absence of an explicit article within the Charter, but also within its own rules of procedure from 2010, the Commission has implied a right to reparation in its interpretation of the Charter. The Commission has, for instance, interpreted Article 7.1 of the Charter on the right to a fair trial to include victims' right to a remedy, noting the protection afforded by Article 7 is not limited to the protection of the rights of arrested and detained persons, but encompasses the rights of every individual to access the relevant judicial bodies competent to have their causes heard and be granted adequate relief. In another case, the Commission has held that there is a legitimate expectation on the part of the petitioner that where the tribunal, in this case the African Commission, finds that a state has violated the rights of the petitioner under the African Charter, he or she would be provided with remedies so as to restore his or her rights, that the state would be cautioned to take measures to ensure that the act resulted in the violation does not repeat itself, guarantees of non-repetition, and the tribunal, the African Commission, could make any other decision it deems necessary in the particular circumstances. These are legitimate expectations from the complainants. So these are two examples of the Commission's jurisprudence in which the Commission has affirmed that the African Charter includes a right to redress for violations of the rights entailed in the African Charter. Subsequent to the jurisprudence or to the entry into force of the African Charter, a variety of instruments were adopted that explicitly provide for the right to redress, including, for example, the Protocol to the African Charter on Human and People's Rights on the Rights of Women in Africa, or the Maputo Protocol of 2003, which explicitly obliges state parties to the protocol to establish mechanisms and accessible services for effective information, rehabilitation, and reparation for victims of violence against women. Apart from those binding instruments, and as you've heard before, the Commission is in the process of developing a convention on the rights of persons with disability, and I'm not familiar with that convention and to what extent it entails a separate provision on the right to redress, but that would certainly be of great interest to you and to MDAC. So in addition to binding instruments, the Commission has furthermore adopted a range of instruments, declaratory instruments, that provide guidance on the right to redress in a number of contexts within the African human rights systems. Very briefly, and again, this can be provided in more detail through PowerPoint slides. The principles and guidelines on the right to a fair trial and legal assistance in Africa, adopted in, I believe, 2001 or 2002, also highlight obligations of states regarding redress. That includes guaranteeing victims access to justice and prompt redress through formal or informal procedures that are expeditious, fair, inexpensive, and accessible, thereby setting certain benchmarks as to what a redress process should look like. The guidelines further oblige states to inform victims of their rights in seeking redress through such mechanisms, and to provide restitution where the state's officials or agents were responsible for the harm suffered. The Commission also, and I think you had gone through this in previous modules, adopted in 2002 the Robben Island Guidelines, which in paragraph 50 urges states to ensure that all victims of torture, as well as their dependents, are offered appropriate medical care, have access to appropriate social and medical rehabilitation, and are provided with appropriate levels of compensation and support. The Commission has also adopted several resolutions pertaining to the right to redress, including a resolution on the right to a remedy and reparation for women and girls victims of sexual violence, which provides important guidance for all stakeholders on adequate and comprehensive reparation for victims of sexual violence. And it has very recently, in 2015, adopted a resolution on the right to rehabilitation for victims of torture, which specifically calls on states to, amongst other things, ensure rehabilitation for victims of torture through the adoption and implementation of national strategies. This brings me to the last point of this section, and to perhaps the most important development regarding the right to redress for victims of torture under Article 5 of the African Charter, which is the development of a general comment on the right to redress by the Committee for the Prevention of Torture in Africa. I understand this has also been mentioned in previous modules, and as you will know, the Commission has yet to adopt the general comment, so it's not yet applicable, but the draft version circulated by the Commission for comments in the first half of 2016 already illustrated the Commission's understanding of the right to redress. And while the general comment explicitly confirms the United Nations Committee Against Torture's general comment number 3, also on the right to redress, it is also significantly different, and it reflects specifically on challenges of victims of torture in Africa. It highlights concepts that are very context specific, such as transformative justice and healing as the ultimate goals of redress and of reparation. And it examines the right to redress in specific thematic contexts as relevant to the continent. So, for example, it looks at redress in armed conflict, redress in transitional justice, redress in sexual violence. The draft general comment also highlights that the right to redress requires a victims-centered approach, which will require state parties to consider the specific case, the circumstances of the victim, and to ensure that they are working with victims and not on victims. It is also emphasized in the general comment that state parties shall take into account marginalized or disadvantaged persons or groups when designing redress frameworks, and to take specific measures to address inequalities. In that respect, the draft general comment calls on states to, for example, provide reasonable accommodation measures on a case-by-case basis. Once adopted, hopefully later in 2017, the general comment will be an important tool for state parties to better understand their obligations regarding victims' right to redress, but also for civil society and for litigants in formulating their remedies requests at national levels, as well as before the African Commission. To conclude this section, as mentioned, the right to redress is firmly established in international law, it's firmly established in the African human rights system, and the African Commission has developed significant jurisprudence, which we will look at in the next section. In this section, we'll examine how the right to reparation has been applied in practice by international and regional courts in Africa. We'll examine the jurisprudence of those mechanisms, in particularly the African Commission, but also the African Court, and see how they have interpreted the different forms of reparation for victims of torture under international law that I had mentioned earlier. As a reminder, the basic forms of reparation include restitution, compensation, rehabilitation, satisfaction, and guarantees of non-repetition. It's important, especially in cases of torture, to emphasize that reparation can take all or several of these forms depending on the violation the reparation is meant to redress and the harm caused to the victim. The UN Committee Against Torture, for instance, has made it clear in a case against Spain involving torture and ill treatment in detention that monetary compensation alone, as provided for by the state, was insufficient, and found that the state was in violation of Article 14 of the United Nations Convention Against Torture, as it did not include other measures such as rehabilitation of the victim. So whatever form, irrespective of the form of reparation provided, it's important that it is adequate, that it's effective and prompt, and intended to promote justice by redressing the violations committed. Reparation should be proportional to the gravity of the violations and to the harm suffered. The UN Basic Principles and Guidelines, which I had mentioned earlier, furthermore specifically emphasize that awards of reparation must be made without any discrimination, providing that the application and interpretation of the basic principles and guidelines must be consistent with international human rights law and international humanitarian law, and be without any discrimination of any kind or any ground without exception. The International Criminal Court, in its first reparation decision, has similarly highlighted the principle of non-discrimination in awarding reparation, indicating that the needs of all victims must be taken into account, and particularly children, the elderly, those with disabilities, and victims of sexual or gender-based violence. So to conclude this, on the principles of awarding reparation, it must be case-specific, it must be tailored to the victim's needs and to the harm suffered. So let's look at the different forms of reparation and how the mechanisms have interpreted these forms in a bit more detail. Restitution as a form of reparation is in principle aimed at restoring the victim to the original situation he or she was in or would have been in before the violation occurred. So it can include restoration of liberty, enjoyment of human rights, family life and citizenship, or return to one's place of residence, restoration of employment, and return of property. These are all facets of restitution ordered by the African Commission, for example. The Commission has also ordered states to afford the victims with the possibility of a retrial, to release victims imprisoned following an unfair trial in violation of Article 7 of the Charter, and to restore the citizenship of victims who had lost their citizenship in violation of the African Charter, and to restore stolen and unlawful expropriated property. However, specifically in relation to gross human rights violations such as torture or rape and other forms of sexual violence, it is often impossible to fully restore the victim to the situation existing before the breach, given the nature of the crimes and their impact on the victims. This will then usually require recommending further measures of reparation in addition to restitution. The General Comment number 3 of the UN Committee Against Torture specifically provides that restitution as a form of reparation should not be simply about restoring the victim to the situation they were in before the violation occurred, but to also take steps to address aspects of that situation which may have led to the violation in the first place. The Special Rapporteur on Violence Against Women has considered that since violence perpetrated against individual women generally feeds into patterns of pre-existing and often cross-cutting structural subordination and systemic marginalization, measures of redress need to link individual reparation, such as restitution, and structural transformation, that would then look at the root causes of the violation. So much to restitution. Compensation, something that is ordinarily seen as the main component of reparation, perhaps wrongly so, given that there are many other forms. According to the UN Basic Principles and Guidelines, compensation should be awarded for any economically accessible damage, as appropriate and proportional to the gravity of the violation and the circumstances of each case. So compensation can be awarded for physical as well as mental harm, for lost opportunities such as employment, education, or social benefit, for material damages including a loss of earning potential, for moral damage, and any costs incurred for legal assistance, medical services, and psychological and social services. The Robben Island Guidelines, as we had mentioned before, provide that victims of torture should be provided with appropriate levels of compensation and support. This is also reflected in the jurisprudence of every international and regional human rights mechanism, including the African Commission, which have repeatedly confirmed the existence of a right to compensation as implied in the right to reparation. If you look at the African Commission more specifically, it does not usually specify the amount of compensation to be provided to the victim as reparation, but instead provides rather general guidance, such as that the compensation to be paid, for example, for a violation of Article 5 should be fair and equitable, it should be just and adequate, or simply adequate. So there's no real consistency, nor a great deal of specification. So the Commission also doesn't break down what type of damages the state should be compensating. This is more or less in line with the practice of the UN mechanisms, such as the United Nations Committee Against Torture, but also the Human Rights Committee. All these mechanisms generally leave it to the discretion of the parties to come to an agreement on an amount of compensation. That approach is in contrast with the approach taken, for instance, by the Inter-American and European Court, but also the African Court on Human and People's Rights, which has an express reparation mandate in Article 27 of the protocol establishing the court. And the African Court, in the few cases it has decided to date, has awarded exact and precise amounts of compensation in several cases, including, for example, a case against Burkina Faso concerning the killing of an investigative journalist and his colleagues. In looking at the amount of compensation owed, the court took into account material and moral damages suffered by the victims. More somewhat recent jurisprudence from the Commission indicates that it may also take this approach in specific cases, but there's no consistency to be identified to ascertain in what type of cases the Commission will actually do specify the amount of compensation owed. In one case against Egypt, the Commission requested the state party, so Egypt, to pay a specific amount of compensation for the physical and emotional damages and trauma the victims suffered as a result of the violation of Article 5 of the African Charter. It did not provide any reasoning for providing the amount of compensation, but simply followed the requests of the complainants. In another more recent case against Cameroon, it awarded approximately $650,000 to a victim who had been arbitrarily detained for 7 years. In coming up with that amount, the Commission took into account the victim's professional activities prior to his detention, as well as the impact of the detention on his reputation. So this is so far about compensation. If we now look at rehabilitation, as the third form of reparation, also highlighted in the UN Basic Principles, which provide that rehabilitation should include medical and psychological care, as well as legal and social services. In the Robben Island Guidelines, it's referred to as a state obligation to ensure that victims have access to appropriate social and medical rehabilitation. The right to rehabilitation is mentioned in several other instruments, including the Convention Against Torture, the Convention on the Rights of the Child, on enforced disappearances, etc. The general comment number 3 of the Committee Against Torture, which I had mentioned earlier, provides the probably most detailed description of the meaning of rehabilitation for victims of torture and other ill treatment as a form of reparation, referring to a holistic concept of rehabilitation that should include medical and psychological care, as well as legal and social services. The African Commission has, in a few cases, confirmed victims' right to rehabilitation, and in a couple of cases urged states found in violation of the Charter to provide adequate medical and material care for persons suffering from mental health problems. That was in the Boerhout and Moore versus the Gambia case, which had been mentioned in your lectures before, I understand. And it has also urged states to take measures to ensure that all persons in detention are provided with proper medical examination and medical treatment and care. A review of the Commission's jurisprudence in relation to torture and violations of Article 5 shows that the Commission does not consistently recommend states to provide rehabilitation to victims of torture and ill treatment, even where it does find a violation of Article 5. We'll come to this in the next section, but this certainly highlights the important role of litigants in ensuring that their complaints entail very detailed requests for rehabilitation, so as to bring the need for rehabilitation in torture cases to the attention of the Commission. Satisfaction as a form of reparation. The UN Basic Principles and Guidelines provide a list of measures that states should take so as to provide satisfaction to victims. These include key components of justice for victims, such as public acknowledgement of wrongdoing and truth and accountability, for instance, through investigations and prosecutions. The African Commission, in its jurisprudence, includes a range of measures of satisfaction, mostly focusing on the need for investigations of the violations and sanctions through the prosecution of those responsible. It is not, at least for now, standard practice of the Commission to outline in much detail as to what steps states should take in this regard. The Commission doesn't provide a lot of guidance to states as what an investigation in line with international standards, for example, should look like. It doesn't refer to the Istanbul Protocol in its reparation or remedies awards. And it also doesn't usually recommend that states issue public apologies or publicly acknowledge violations of the African Charter. This is somewhat in contrast also to the recent jurisprudence of the African Court, and in stark contrast to the Inter-American human rights system and where the mechanisms, the Inter-American Commission and the Inter-American Court, usually, I think in about 80% of cases, request the state to publicly acknowledge violations of the American Convention. Such acknowledgement could, for instance, include a public statement, a public apology, or a declaration by the state. The last form of reparation highlighted in the UN Basic Principles and other declaratory instruments are the guarantees of non-repetition. The right of victims to be guaranteed non-repetition of the violations they suffered is a fundamental part of redress. Central to that guarantee of non-repetition is combating impunity for human rights violations, as also included in the UN Basic Principles. And most, if not all, international and regional human rights bodies have called on states to adopt measures to guarantee non-repetition of the violations. The most famous example in our context, and you had mentioned this in your previous modules, is the African Commission's case in Purhoit and Moore versus the Gambia, where the Commission requested the relevant state to repeal legislation found to be incompatible with the African Charter. In other cases, the African Commission ordered other measures of guarantees of non-repetition, for example, establishment of a national reconciliation forum to address the long-term sources of conflict and to resolve issues of land and water rights, to desist from adopting amnesty laws for perpetrators of human rights abuses, and to ratify international and regional conventions such as the Maputo Protocol. So this is a very brief overview of how the Commission and other mechanisms have interpreted the different forms of reparation. It's standard practice of all major international and regional human rights mechanisms to award several forms of reparation where a violation such as torture has been found. At the African Commission, such jurisprudence is increasing, and the lack of consistency, though still of concern, I think is increasingly being addressed, and litigants play an important role in making sure that the Commission, but also other human rights mechanisms, increasingly apply the international and regional instruments providing for all forms of reparation. And we'll come to this in the next section. So this leaves us with the last section of this module, and how the international and regional framework and the jurisprudence highlighted above could be applied to secure effective remedies for victims of torture with mental disabilities in Africa. As mentioned at the outset, aside from the Gambia case mentioned throughout this training, I'm not aware of any other case or cases involving victims of torture with mental disabilities in Africa. So practice in this respect is certainly limited and certainly needs to be developed, which I hope will be one of the outcomes of this training. What lessons learned from other cases could be applied in litigating on behalf of victims of torture with mental disabilities in Africa, specifically in regards to requesting or securing effective remedies? Well, if we look at the previous section on how the Commission in particular, but also other human rights mechanisms, the court, for example also the East African Court of Justice, formulate reparation awards, a key lesson learned is that in relation to regional, sub-regional, but also international mechanisms and arguably national courts, it will be fundamentally important for complainants in any case to outline in great detail the remedies requested. It will not be usually sufficient to simply argue that a violation has been committed and that as a result the state should provide, for instance, compensation and rehabilitation. Courts at least as far as the regional courts are concerned, and the sub-regional courts like the East African Court of Justice or the ECOWAS Community Court of Justice will usually not or rarely adopt reparation awards that were not requested by complainants. Even where complainants do request specific forms of reparation, those should be outlined in detail. The lack of detail included in many complaints submitted to the, for example, Commission to date has contributed arguably to a somewhat inconsistent approach by the Commission to remedies so far. The Commission is largely basing its remedies jurisprudence on what the claimants or the complainants put into their complaints and their submissions. So where the complainants do not have any information on the remedies they would like to see, the Commission is hard-pressed to identify what is necessary to redress the harm suffered by the victim. So wherever possible, include as much detail as possible in relation to the remedies requested. It is also important to explain how this will serve to redress the harm suffered as a result of the violation. If a victim of torture, for example, requires specific medical and psychological treatment as a result of the torture, then this should be set out and explained in the complaint. Why is this specific treatment necessary, and why will this treatment redress the harm suffered? Where a victim of torture has lost work and employment opportunities, this should also be set out in detail in relation to the compensation requested. It may not be necessary to specify the amount of compensation sought. Might be sufficient to simply list the different categories of economically accessible damage, and to then leave it up to the Commission to spell out the compensation owed according to these categories. However, having a precise amount of compensation in the remedies request may help. More recent jurisprudence from the Commission suggests that this can help the Commission to identify a precise amount of compensation owed to the victim. Where, for example, a specific law or state practice is responsible for discriminatory treatment resulting in a violation of Article 5 of the Charter, this should not only be highlighted in the merits, but also in the remedy section of the complaint, and the state should be requested to repeal relevant legislation or practice as a measure of non-repetition, just like in the Gambia case. Where state authorities are known to use torture and other forms of ill treatment, for example, a specific police force or a specific army unit, human rights training, in addition to criminal prosecution and disciplinary sanctions, etc., of those responsible, should be requested as a form of non-repetition. It would also be important, specifically in relation to complaints submitted to African human rights mechanisms, to highlight any discriminatory aspect of the treatment in the complaint itself, and to then come back to this in the formulation of the remedies. So where the Commission has made a finding that a violation was committed in a discriminatory fashion in violation of Articles 2 or Article 18.3 of the African Charter, this should be reflected in the formulation of the remedies to ensure that the remedies address the discriminatory character of the violation. For example, in the context of sexual violence, the Commission's resolution on the right to a remedy and reparation for women and girls victims of sexual violence, as I had mentioned earlier, that resolution stipulates a number of factors to be considered to ensure that reparation awards are gender sensitive and non-discriminatory. These include, for example, tailor-made reparation recommendations specifically adapted to the victim's needs, interests and priorities as defined by them, Measures of access to equality, positive discrimination, are required to take into account the reasons and consequences of the crimes and violations committed in order to ensure that they are not repeated. Now, these are some of the lessons learned that can also assist in the litigation on behalf of victims of torture with mental disabilities in Africa. This brings me to an end for this module. I hope this was useful, and I would appreciate if you have any more questions that you do get in touch with me directly. My email address is jürgen@redress.org, so that's JUERGEN @redress.org. Thank you very much.